I wanted to welcome everyone and thank them for joining another one of our financial wellness webinars. We've been doing these for over a year now, so I just appreciate continuing to see more and more people join them for the different topics we presented. So this one will be a little more high level on this, and it's meant more to be a multi-generational conversation. So we have a lot of clients. Our business is multi-generational. So I've worked with my dad, and we have a lot of clients where their children have come into the business, their adult children, and worked with us. But we also have situations where even if we're not working with the adult children, our clients, as they get older, have put a lot of things in place for the future, but then that's not communicated to their kids. And so there's concern between the parents or the children about what documents do you have in place? Should I have in place? And then how do I tell my children that? And so, it's something where we want to help facilitate those conversations. So what we'll be going over is what documents should you have in place and high level of what they do, but then also the importance of if you do these, communicating to your children, I do have these documents in place. I've worked with someone like Alyssa. Here's the firm information. So if you ever need to access these documents, you know where to go to get that information. So with that, I will get us started. As I said, Alyssa's joined us before, and we've worked with her and her firm for years. So I appreciate her continuing to deal with us here. Alyssa and her firm, Ansell and Anderson, concentrate their practice in estate planning. They do it all in estate planning. So trust and estate, gift tax, multi-generational planning, probate. So they cover the gambit there for our clients and have done so over thousands. And Alyssa has graduated magna cum laude from Boston University, summa cum laude from Suffolk University Law School, and where she was also the note editor for the Suffolk University Law Review. And she received her master's degree in taxation from Boston University School of Law. So she's got a few degrees ahead of most of us here and a very impressive resume. So I'm glad she's able to join us. So with that, Alyssa, I'm going to share my screen to show our presentation.
Perfect. I'm happy to be here.
In a local law firm here, Christine Anderson, some of our clients have worked with as well, so they may recognize her in the picture here. And today's conversation will be split with Alyssa going over the estate planning side of things, and I'll be touching on some of the more long-term care planning. So with that, Alyssa, I will let you get started, and you can let me know as I should move down on the screens.
Perfect. So I was going to start talking about, a brief overview. I only have, about half an hour to talk about this stuff. So a brief overview of documents everybody should have in place. But, keeping in mind that I understand a lot of you watching probably have some of these documents in place or, have thought about this planning before. And those of you who haven't, would want to meet with somebody to do this. But, I'm going to touch on wills and trusts and financial powers of attorney and healthcare advance directives primarily. A couple other things that are mentioned on this, beneficiary designations. I will discuss a little bit of that. And then living wills are part of the New Hampshire Advance Directive for healthcare. And some of these other things are important conversations to have with your family. So it's a good list here of items that you might want to consider. One of the things about estate planning documents is that they are living documents. So for those clients that are, have done this before, it's not something that you can just shelve and never think about again. And, in conversations with loved ones who, you're trying to bring into the process with you, if you are talking to your parents about these documents and they're sharing with them, you might want to ask them, when was the last time that they actually updated these documents? We find a lot of clients who did it first when either their first child was born or when their last child was born. And now it's been 30 or 40 years, and that is their estate plan. Yeah, they did it, but they haven't updated it. And so as people, particularly as they're children age and become adults themselves, a lot of the provisions in these documents may need to be updated. And it isn't as if those documents are completely invalid or that they might not work, but some of the people named in them may not be good choices anymore. A lot of young families start out naming either their parents or their siblings. And, when they get to be, 70 or 80, their parents are unlikely to be good choices if they're still alive even. And their siblings may also not be a great choice for, naming for making their healthcare decisions and their financial decisions. It may be time to think about transitioning some of this to your kids. So we say, if you haven't looked at these documents in 10 years, it's probably time to do a thorough review of all of your estate planning documents to make sure that those decisions that you've made are still appropriate. It doesn't matter that you named guardians for your children and now they're 30. It's okay. They're not going to need a guardian. I mean, it's just, it would be ignored. But, the who you named as executor or trustee or agent under these powers of attorney definitely may need to have consideration in updating over time. Some of the documents that are really critical are the trusts and the wills. And so I'm going to give a brief overview of what these documents do. A will is a direction of where assets pass through the probate process. And I think one of the common misconceptions I have from clients, even those that have previously done a will, is that, well, I did a will, so my kids won't have to go through probate. That is not the case. A will is simply a direction of you telling the court where you want your stuff to go when you die. But it is still a court process. So having a will does not avoid probate, but it is a good first step in determining where your assets go. If you don't have a will and you pass away, your assets that are in your name would go by what's called the intestacy law. So every state has a law that says where assets go for people that die without a will. In fact, I think still the statistic is that the majority of people do actually die without a will. So in New Hampshire, for example, if you have a spouse and children, your assets may be split between your spouse and your children. If you don't have a spouse, it would all go to your children. If you have children, if you don't have children, it would go up and out your family tree until they find living relatives. Do occasionally get people worried that if they don't have a will, it's going to go to the state or something like that. That's not the case. It still goes to your family, but you have lost the ability to dictate how you want it to go. So the will is your tool to tell the court how and where you want it to go. One of the reasons people do trust, though, is to avoid probate. So probate is just the court process of transferring assets to your heirs. Items that are in your name alone at the time of your death have to go through probate. You can avoid probate by beneficiary designation of some of your other assets. The classic example are things like retirement accounts and life insurance. It's virtually impossible to have those accounts without beneficiaries listed, although not impossible.
Yeah.
So it's always a good time to review your beneficiary designations. Whether you have a will or a trust, the less that goes through probate, the better. So the more that can have beneficiary designations, the better it is. And certainly, the classic examples are life insurance and retirement accounts that can have beneficiaries listed. And again, if you are somebody that's, starting to help maybe your parents look into some of this, one of the things we find is particularly after one spouse passes away, that clients may not have updated beneficiary designations. And while, the best practice would be that they had a primary beneficiary and contingent beneficiaries, in the Ozzie and Harriet scenario, first to your spouse and then to your kids as the contingent beneficiaries. Not everybody has that set up. So if the only beneficiary was their spouse and now their spouse is deceased, that asset, that life insurance policy that used to have a beneficiary now no longer has a beneficiary. So particularly in helping clients after the death of a spouse, and helping your parents after one of your parents passes away, looking at those beneficiary designations. The estate planning documents are almost always designed to anticipate, particularly for a husband and wife, that one spouse is going to die first. And there may not need to be updates after a spouse passes. But other things like beneficiary designations, sometimes they're set up that way and sometimes they weren't. So a review of those beneficiary designations is really helpful. So what is a trust? Trust is just agreement. Your main estate planning trust is a revocable trust. And at the end, I'm going to talk a little bit about irrevocable trusts, but right now I'm going to focus on revocable trusts, which are your main estate planning trust. It's the will substitute. It's the trust you do because you don't want your family to have to go through probate. Mm-hmm. The other reason people do trusts is for management of assets after they pass away. Obviously, the classic example is somebody that has minor children and they don't want their minors or their young adult children to inherit a large lump sum of money. But there are lots of other reasons we find that clients may want a trust to provide for guidance after they die. People with special needs, children or grandchildren, and they want to provide a benefit for them, but not to disqualify them from government assistance they're receiving. Spendthrifts, clients that just are concerned that their kids are not good with money, or a popular one is not saving for retirement right now. So I got a lot of clients that come in and want to set up their trusts so that their inheritance becomes their children's retirement benefit. So we're holding trusts until they're 55 or 60 or 65. Issues with their children's marriages. They're not happy with their children's chosen partners. Concerned about a divorce. Unfortunately, we hear more often than not about concerns of one spouse controlling the other's finances and concerns about that. There's ways to manage that in a trust so that your child benefits and their spouse has limited access to it. So lots of different reasons people want to manage assets. And the other one is substance abuse issues. So unfortunately, it is a not uncommon problem for one member of a family to be suffering from some kind of substance abuse issues, and wouldn't be ideal for an outright distribution of money if a person passes away. So, yes, trusts a lot of the time are about probate avoidance, but they can also be about holding assets to benefit another person. And I think in talking about covering this with family members, some people really don't want to disclose what their estate planning says to their children ahead of time. But particularly if you're going to do something like hold assets in trust, having a conversation with your family and who you're putting in charge as trustee about how you would want that managed. Sometimes these are difficult conversations to have, but setting expectations is very helpful. And, educating the person that you're designating as trustee about your thought process in not giving, one of your kids an outright distribution. Obviously, in some scenarios, with a special needs child or something like that, it's probably not a secret that they're not going to be able to have, an outright gift. But in other scenarios, it might be a surprise, or, there might be sibling relationships that you need to think about there if you're putting a sibling in charge of another sibling's money, which isn't always ideal, but can be done. And there's workarounds to finding an ideal solution for doing that. So I think an open communication can be very helpful, particularly if you're doing some kind of trust that is not just here's your money, outright distribution just to avoid probate, but they're really useful. So, we find a lot of clients wanting to do trusts. Mm-hmm. The other thing that comes in is, naming your trustee and giving information to that trustee about, I talked a little bit about what the provisions are, but also trusts can be used if you yourself become incapacitated, somebody else managing those assets for you. And a lot of trusts have some kind of trigger mechanism for when, if it's me, when do I stop being able to be my own trustee? When does somebody else have to step in for me? In our office, a standard provision is that we actually need, if I don't voluntarily give up control, I need 2 doctor's notes to prove that I'm incapacitated. And then at that point, I would no longer be the trustee of my trust. Lots of trusts have different provisions for what triggers the transition from the original trustee to the next trustee. Understanding that and having a communication, particularly as we age, and that process may be closer in time when somebody else might need to do it. And it's not always incapacity or not. So we have clients that realize they want or may need help managing their affairs, but they're not to a point a doctor's going to determine they're incapacitated. Maybe at that time they want to add a co-trustee. They still want to have control over their trust, but they want somebody else helping them. So, a lot of people think, oh, it's either me or them, but that's not necessarily the case. There are mechanisms in trusts, particularly to allow somebody to act as a co-trustee with you. We have a lot of clients that decide at some point to add their kids as a co-trustee because they realize that they might be starting to have some diminished capacity issues or issues just managing their finances, sometimes from a physical standpoint, and obviously sometimes from a mental standpoint. But a conversation about, what that mechanism looks like with your kids, particularly if it is your kids or whoever else it is that you designate as trustee, to protect you as the person that created this trust, and what their job would be in managing these assets for you yourself. What is your thought process about that? On the reverse side of that, you do want to be careful about realizing that the trustee only has so much authority. So I sometimes have clients think, oh, well, my trustee can do something that's not written in the trust. And that's not necessarily the case. So I had a client in here thinking that their trustee was going to be able to make some, $5,000 gifts that they wanted to give out. It's not something that it wasn't in the trust. You can't just dictate that to your trustee. So if there is something that you want to carry out, you want your trustee to do after you pass and you're just giving them instructions, it's important to know whether they have that authority or not. And maybe a conversation with your attorney about whether, those additional instructions that you're providing to your trustee are even possible. One of the 2 important documents to have in place are for planning for incapacity are financial powers of attorney. So, this slide talks about different versions of powers of attorney: general powers of attorney, limited powers of attorney. For estate planning purposes, generally, we're talking about general durable powers of attorney, which means that this power of attorney survives your incapacity, and it is general in that the person designated can do pretty much anything you can do with your finances. And it's really critical, should something happen to you and you become incapacitated, that you have a power of attorney. I talked about trusts being able to manage certain assets if you become incapacitated, but even if you have your trust, mostly, assets in your trust, there's probably going to be things outside of your trust. For example, your retirement accounts can never be put in your trust. They could be beneficiary to your trust or avoid probate by beneficiaries. But while you're alive, it's only a power of attorney that would actually have access to those those assets in your retirement accounts. And then other things like, creditors. So your credit card company doesn't care you have a trust, but they could talk to the power of attorney. So even if you have a trust, you still need a power of attorney. And if you don't have a trust, you definitely need a power of attorney, because this is the person who's going to be able to manage your affairs if you are alive but incapacitated. different people have, different attorneys have different ways of doing these. Some of them spring into effect, which means that they're only effective if you become incapacitated. At our office, we don't do it that way. They're effective as soon as they're signed, but our clients typically ask us to hold them until either they tell us to release them or we receive a note from a doctor saying they're incapacitated. Just like I was talking about with trusts, we often have clients that realize they want help managing their affairs. They're not at a point where a doctor is going to say they're incapacitated, but they want either their spouse or their child or somebody else that they've designated being able to help them manage their financial affairs. And so they can tell us that they want this released, and there's no need for them to be incapacitated by a doctor indicating that. But it's important, again, to have a conversation with whoever you've designated about the fact that they are designated in this role, and then to provide them information about your financial assets. So one of the things that we have that's really common is that, you may have named somebody, but not provided them any information about the assets that you have. Now, if you have a financial advisor, like the folks at Brophy Wealth Management, they're going to have that information for you. They're going to have a lot of that information to be able to be a resource for your power of attorney or your executor when you pass away. But having all of your information in, documented, where are your accounts? Where's your life insurance? Do you still have life insurance? What credit cards do you use? What are active? The more you can list that information and provide it in a easily accessible way to the people that you're designating, the greater ease that they're going to have in doing that, so that they don't have to spend the first year of managing your stuff just being an investigator and trying to find out what the heck I'm supposed to be managing. So I think the biggest gift you can give to your family is, kind of organizing this information for you. So this is talking about guardianship. And one of the whole reasons of having powers of attorney and trusts is to avoid the need to ever have a guardian. So if you don't have these documents in place, and the next slide is about advanced directives for healthcare. Again, that's the purpose of having one of those documents, is to avoid the need of a guardian. A guardianship is a really time-consuming, costly process. So what happens is, if you don't have financial powers of attorney and healthcare powers of attorney in place, then your family cannot step in and make decisions for you, generally. And so if that was the case, you may need to get a guardian over the individual that you're trying to help. A guardianship, you do need to prove incapacity. So this wouldn't be useful if you just wanted help managing your affairs. This is only if you're truly incapacitated. But at that point, it typically involves two attorneys. The person that needs the guardianship always has to be represented. And then typically the person seeking representation also gets an attorney. So now you're dealing with multiple attorneys. It's actually a court hearing. Most of the stuff, even probate, no one ever ends up going to court unless there's a real dispute. But a guardianship is an actual hearing in front of a judge. It can take time and money. And then there's annual reportings to the court. So if at all possible, avoid guardianship by getting your affairs in order and get your powers of attorney in place. If you can go to the next slide.
Okay.
So a lot of what we talked about was financial, but this is the other aspect of kind of end of life care planning and planning for your estate, is medical advance directives. So in New Hampshire, we have a combined advance directive for healthcare, which includes a power of attorney and a living will. It does not include a DNR. So this is on the list here. A DNR it's a medical directive that only a doctor can give you. A lot of people are concerned or think and get confused by the two different terms. But a do not resuscitate order is limited to whether a doctor would restart your heart, and it's a medical order. But the legal documents are the power of attorney and living will. I would say that one of the more difficult conversations, but important conversations to have with your family, is about medical directives and carrying out their wishes. finances, it's easy. You can make a spreadsheet and say, this is all my assets. And if I, something happens to me, go to the drawer and get it. But what your medical philosophy is, the kind of care you'd want, I mean, these are hard decisions for people to want to think about, but also necessarily communicate, but critical in the fact that if somebody else is making your decisions, them knowing what your wishes are is really, really helpful. Typically, the document itself is really broad and doesn't provide a lot of instruction to the people that you're designating. In New Hampshire, for example, it just talks about whether you'd grant your agent the ability to terminate life support if you would think it was excessively burdensome or had no reasonable hope of recovery. Those are big words that don't mean a whole heck of a lot in deciding where you're drawing the line. So a conversation can go a long way in helping people decide that. There are a couple of resources if you wanted to provide written guidance. One of them is a site called Compassion and Choices. It's compassionandchoices.org. They have a lot of supplemental materials that you can fill out to provide additional guidance if you prefer written guidance. And the other one is called the Dartmouth Dementia Directive. It's put out by Dartmouth. It deals solely with clients that are concerned about their care should they get dementia. It's a very detailed document, but a lot of clients that may particularly have that run in their family feel good about being able to give their family their directions about should they have dementia, what kind of care they would want. So I think, financial stuff is really important, but sometimes easier to organize and provide information. The healthcare one, I think sometimes because it's difficult to think about, gets put aside, but it's really critical in providing information to your family about the care you'd want. And so beyond just doing the advance directive, having conversations about care and having conversations about end of life care, or providing written guidance to your agents if that's something that you can do. So the only other thing I was going to mention, and this talks, and I said I would do it, is irrevocable trust. So I'm running a little behind. Sorry, James.
Oh, that's fine.
So irrevocable trusts, this kind of tucks into the long-term care planning part of it. A revocable trust is not a protective trust. It's not going to protect your assets should you have to go into a nursing home. I have a lot of clients have that misconception that if they have a revocable trust, if they go into a nursing home, their assets are protected. They are not. A revocable trust, you have complete access to your assets, and so do your creditors, which would include you having to pay for your own care. If you are interested in protecting assets so that they wouldn't have to be used for your care, then you're really talking about typically an irrevocable trust or making an outright gift to your family. The rules for Medicaid, which is what you would be trying to qualify for. So Medicaid is the government assistance program that provides care for those that can't otherwise afford nursing homes. Has a 5-year look back, which is what a lot of people are familiar with. A lot of people know that term. What it means is that you can't make a gift within 5 years of applying for Medicaid. Otherwise, you're disqualified. So if you were going to do planning to give assets away, you need to do it at least 5 years from needing to apply for Medicaid. And oftentimes people want to consider doing it in an irrevocable trust. Depending on the assets that you're putting in the irrevocable trust, you can continue to receive the income from that trust. The rules regarding houses in irrevocable trusts do vary, particularly by state. So for example, New Hampshire and Massachusetts treat these trusts very differently. So they end up being more popular in Massachusetts. Massachusetts says you can continue to live in a trust owned property, an irrevocable trust that owns property for your lifetime, and Medicaid can't get those assets. In New Hampshire, you actually have to pay rent to live in your home. So it ends up being a less popular approach because it needs to be fair market value rent that you're paying into this irrevocable trust if you want to put your home in an irrevocable trust. So a little less popular in New Hampshire because most people don't want to pay rent in a home, particularly they've just paid off their mortgage or something like that. And in Massachusetts, maybe a more popular option. But it's the irrevocable trusts that are going to be the long-term care planning tools, not the revocable trust. The revocable trusts are really just about getting your affairs in order. So I can turn it over to you, James.
Excellent. Well, thank you, Alyssa. And one thing I'll say before I leave this slide is you're spot on with what I see with our clients as well. I've had a handful not go to your office or get the documents done just because they didn't want to have the conversation about the end of life decisions, right? It had nothing to do with the finances and nothing to do with the trustees. It was, I'm just not comfortable making those decisions. Fortunately, they haven't ended up doing it, but honestly, some of these people took 2 or 3 years before they were willing to go in and do that. But the other thing too is you mentioned how important it is to communicate your wishes on the end of life decisions, why you're doing what you're doing for the trust, talking to trustees. I've seen a lot of cases too where it becomes a sibling thing, right? So someone passes away and there's money to be had, and it affects relationships. And we've seen cases even when it's not money, but it's an end of life decision. One says, mom would want us to pull the plug. One says mom wouldn't want us to pull a plug, and that becomes a huge issue. So having, okay, well, here's mom's wishes, it helps that quite a bit. But also having conversations with trustees. I've had a few people who, one of the reasons actually they came to talk to a financial planner was they had become the trustee of their parents' assets and they didn't want to be. And so
Right.
so, or now they want to be, or else they just weren't comfortable doing it. And so they want to be able to say, okay, I hired someone that helped me make these decisions. This wasn't just on me. So be talking beforehand. And then the last thing you had mentioned too, the thing I find often is, this is New England, and everyone has they trust people, but they take care of themselves. So a lot of our clients have these small accounts somewhere else too, right? They may have a
Right.
$20,000 account somewhere that nobody else knows about but them, because that's really their money under the mattress. So when they pass, nobody knows that exists. I maybe they were comfortable enough to tell me I have an account at Vanguard. And so I have a note that says they have an account at Vanguard.
Right.
Is kind of the best case scenario. So it is important to make sure that you do have these things listed out, and then that somebody knows where it is. I've also had that case. I had someone who they felt they had the conversation with their dad. Dad had said, "Don't worry, all these things are automatically set up. Mom will be fine when I pass." And really, it was it's too high level, right? So he knew that there to go to this bank, but didn't know how many accounts were at the bank and didn't know what account was paying what bills and that kind of stuff. So I just want to.
Yeah. And the other one is, if you can, I had a client recently that thought, same thing. Parents said everything is set up. They come to find out that their parents had tried to do these documents on their own. And they come to us with a will that isn't witnessed, so it's not valid. The power of attorney is page 2 and 3 of in the middle of their trust. So not a valid power of attorney, and now not a valid trust because the trust doesn't make any sense.
Mhm.
And so, they may have thought that they did these documents, but really now have left their kids with kind of a mess because the documents are in such bad order. So, if you can get more information about it, I've seen, no, I went to an attorney, the attorney is so-and-so or something like that. It is helpful to have that information to make sure that, mom and dad are taken care of.
Exactly. So I'm going to go to the next section in the presentation, which is, it's on long-term care planning. As we said, we've done a whole webinar on this, is also on our website. So this is just more what things should you be making sure you have in place in some way, and then communicating it to your children. And you don't have to, just Alyssa say, you don't have to get into the nitty gritty, but just this is, if it's insurance, call Brophy, and this is the insurance company. If it's not insurance, I know I don't have insurance. Here's why. Here's what we're planning on doing. All right, we have 2 houses. We plan on selling this one to fund it, or we plan on moving into this one, and making sure your kids know that, because by the time that happens, you may not be able to communicate those things. So, okay, one thing here, and I have some of these listed out in some other places as well, but just using New Hampshire and Vermont, the cost of care is extremely expensive, right? $210 to $440 per day. So some people pay over 250,000 a year for 24/7 home care, and that's another thing. I don't know if that's unique to New England or not, but many of my clients also their long-term care planning is that they're going to die in their home. So that can be a plan, but do you have $250,000 set aside per year to do that? So instead, again, some people that the plan is to stay in home, but then there's also modifications you may need to make. So, are those kinds of things planned for? If there's mobility issues, making sure that that's addressed ahead of time. But then there also one thing that's become very popular are these continuing care communities. So those are the kinds where if you still have, these have to be applied for while you still have functional health, and it's not just mental and physical to be able to apply for these. And oftentimes it's you go into independent living, you have your own condo or apartment, and you're able to live there and live your life. But if you do need additional care as life goes on, you're guaranteed to be able to move. But I say further in. I think of it like a bullseye. You go further and further into to a target as you approach the bullseye there. But you're guaranteed protection from there. Whereas if you wait at home until now you need a care, it's what facility has an open bed, right? And that can get more difficult. So just talking to your kids, saying, I'm actually part of one of these communities. This is why I live here, and if something happens, I would be able to move in from here to here, and here's the cost that may be associated with. So those are some important things. Um, there's different ways to fund it. So making sure your kids know, again, we have money set aside that we're going to just fund this with our own savings, right? We have an excess of retirement savings. We have a home we're going to use, or we have an insurance product, right? We bought insurance when we were younger. Now we have that $220 to $440 a day covered. There's those continuing care, like I talked about, and there's quite a few in New Hampshire in particular. We're very fortunate to have a lot of care here. Home equity. So this is something that it can get a little more complicated, but some people will end up using the value in their home to pay for the care. As Alyssa said too, though, there's certain things around Medicaid that can be connected with that. But then there is also the final plan of Medicaid planning. So we do have, some people as well. They say, you know what, we don't have an abundance of retirement savings, so we wouldn't come up with the extra 250. But they're not willing to or not able to pay for the long-term care premiums for insurances. So the plan can be for Medicaid, but again, just have to communicate to your children we have this plan in place, particularly if you're doing something like irrevocable trust, because now they have to get involved. But so the high level here is just to make sure that if you have something, people know who to call, what the plan is, and where the funds are coming from. Another thing, the insurance companies try to be very good about this, but oftentimes there's a section that says, if you don't get paid from me, here's someone else you can contact before my policy lapses. And we always encourage people to do it, but oftentimes, in addition to beneficiary designations, that should be updated. So they're not sending mail to a child that's moved, and you pay for 10 years for a policy, you need it, and because you need it, you didn't remember to pay the bill. So there's those sort of things that we need to stay on top of, and that's what we work with our clients on. But just make sure that these are the conversations to have, either to ask your parents, are these in place? Have you thought about these things? Or just if you have as a parent, communicate that. And then the last thing as well on here is veteran benefits. So there are some coverages for long-term care, but more so even things like pension payments and such that people need to be aware of. One other thing here of why it's important to have a plan is right. If you can kind of see on the chart here, the top providers of the unpaid care are your adult children. So making sure that they are aware of what you've wanted in place and that you have a plan. And also, for children, it can be a hard conversation to bring up. Mom and dad, have you thought of this? But also being aware of if you don't have that conversation, you're going to get pulled in anyway. But it would have been easier to talk about it 5 years in advance. Um, just so these other things talk about some of the other costs of care. And so in this case, roughly a third of people are paying 250,000 plus, and not a lot of people have that extra money set aside. So it has to be a plan in place for that. As I mentioned too, there are different types of care. So, if you are staying at home, right, in home care, you can have someone come and, whether it be visiting angels or it be skilled nursing, you have come in. The So that is an option, right? I'm going to stay in my home. That being said, it does get as expensive if you have to have 24/7 care, if not more expensive than going into a nursing home. But also, what you run into at that point is not all nursing homes will take you because if by that point your health may be such that they already know the expenses and the liabilities with that. There are also some for the initial time frame when you may have a physical ailment or early signs of dementia. There are some other cares like adult daycare. As I have some clients where either veterans or Easter SEALs, for instance, are helping cover some of those costs. Um, and then there is, the full blown nursing home. But having something to pay for these level of costs, right? This is New Hampshire's. This I pulled this from Genworth, it's a company that has a annual cost of care seminar or survey. So we'll put this link on our website. You can play around a little bit. We do have clients in 27 different states, so you can see what is it going to be in my state. For instance, Florida is less expensive, so our snowbirds, that's their final destination. But as I said, if you've got two houses, you want to make sure your kids know our plan is to sell the New Hampshire home. Housing prices have been favorable. We're going to use that money just to live in Florida and be taken care of. And you also want to make sure if you have a child in Florida that they know this is your plan. I'll say one thing is my dad is one of six children. And when my grandfather was needed to move into assisted living, my dad said, well, great, you've got six of us across the country. You can pick where you want to go. And he initially picked Tennessee. None of his kids live in Tennessee. The closest drive was to North Carolina, which is not a daily visit. So it had to have that conversation. Okay, Dad, I think we need to look at one of the six states where someone lives so someone can take care of you. And then the siblings had a talk on who uh, had the time and the ability to help take care. So that is a very high level part of our conversation. If you do have questions, please feel free to reach out to us. There's our wealth managers listed on here. And we can follow up with Alyssa if there's anything, any questions you may have for her. This is a very personal topic as well. So if you, as I said, if you're more comfortable scheduling a meeting, whether that be on your own to talk about your plan, or if you want, we also facilitate these family conversations. Sometimes it's easier to have a third party bringing these different topics up. We're also happy to do that. So if you want us to meet with your adult children, or if you're an adult child, if you want us to meet with your parents, just to talk about what things need to, what do we have in place, we're happy to facilitate that.
I was just gonna say, if anybody does have questions, I'm always happy to answer them. And so, James has my contact information. If anybody just wants to shoot me an email, I'm happy to answer that question if I can.
Excellent. Well, thank you, Alyssa. Thank you, everyone, for joining us. And I hope this was helpful. And I look forward. We have a few more of these planned throughout the year. I believe our next one will be on cybersecurity and identity theft. So, unfortunately, a very topical issue as well. All right. Thank you, Alyssa.
Thank you.
Bye.